So we will get rolling here. We'll call the meeting to order. Any additions or corrections to the agenda? I don't believe so. Alrighty. Minutes of the previous meeting. Everybody read those? Motion to accept. Chad makes the motion.
I make a motion. Yes.
Okay. Somebody's second. Tom second. All in favor signify by saying aye. Aye. Opposed, same sign. Motion carried. As far as open mic, there's nobody here, so I guess we'll just move on to Hurdsfield Project with the updates. Thomas, anything with that?
After the last meeting, there was batteries and a cable to replace. Those were replaced on, the batteries were replaced on both monitoring station, and the cable was replaced on monitoring station number 1. They're back up. There may be an issue with the probe at station 1 due to, there was a large break in that cable, so there's a little bit more troubleshooting on that one to do prior to next year.
Okay. Alrighty. Okay, if that's it, we will move into the roller dam issue. Gail had emailed out findings of fact. Did everybody get a chance to look at that or not?
Yeah.
Everybody did?
No.
No?
Not everybody.
Okay. Okay.
I won't say no, but not everybody.
Okay.
I can summarize them if you'd like, Larry.
Yeah, go ahead.
Yeah, so just to refresh the board, the findings of fact are purely procedural because most of the administrative actions on this are final and unappealed, and the district and board are just acting under the direction of the DWR, which is what the Century Code requires. So the findings start with going through the complaint that Thompson filed, the initial investigation by the water board that led to a local hearing between John Roller and the water board, and then ultimately the water board's decision that the dam did require a permit in order to remove it. Then it notes that John Roller appealed that, and the Department of Water Resources investigated. I included the findings from the DWR, including in paragraph 12, the key findings being that the crest elevation of the dam was 1848.5 feet. The ground elevations, according to the state, were between 1840.5 and 1843.5, and that the maximum dam height then was approximately 5 to 8 feet above the natural outlet, which the state calculated to lead to just over 4,000 acre feet of water being held back in the reservoir by that dam. And so then I note that the DWR filed its technical findings into a memorandum and then issued an order to the Water Resource District back to our board, finding that the dam that John Roller constructed required a permit and therefore is not compliant with the dam permitting statute, that the water board was directed by the state to allow John Roller and Thompson an opportunity to try to come to an agreement on the height of the dam, and if they could agree, then to direct that John must apply for a permit to that agreement, and that if they could not come to an agreement, that the dam then must be removed in order to no longer require a permit under the state statute. So then I noted that the board had met with John Roller in 2022. He discussed his attempts to come to an agreement with Thompson. He briefly engaged with Apex to look for some solutions, consider permitting, and then finally I just note that ultimately, no agreement was reached, no permit was applied for, and that the respondent, John Roller, passed away in February 2025. And then starting with the final 3 paragraphs of the proposed findings, I just note that the present owner of the property is Linda Roller, with the Roller Children Irrevocable Trust, Jessica Lervick and Lindsay Zion as co-trustees of that trust. That at the October meeting, which was the last board meeting, Lindsay appeared on behalf of her mother and the property and said that although they don't object to the dam being removed, that the farmstead that the dam protected is no longer being used or maintained, and that although they don't plan to object or fight the removal of the dam, she did express that they don't currently have any means to remove the dam and they don't wish to be responsible for the costs. And then the board did instruct at the last meeting our firm to prepare these findings in order and for Apex to investigate what would be the removal condition to make the dam compliant. So I worked with Thomas and Jennifer on that. And Apex's report on that was that they're recommending a 20-foot wide breach of the dam to an elevation of 1843 in order to restore the natural outlet. And so according to Apex, that would bring this dam back into compliance with the requirements of the Century Code. Jennifer had estimated the cost of a contractor to do that work at approximately $6,500. She said if the rollers were to cooperate in terms of spreading and leveling the dam material that has to be removed for that breach, that could be reduced to approximately $5,000, she estimated. So I asked her to do that and included that in here so that if the board approves this, in the notice of decision to rollers, I'll ask them to confirm in writing permission for the district's contractor to do that if they don't remove the dam on their own. And then I just want to go through the proposed order that we're recommending to the board. Number one, it be that the dam be made compliant with the Century Code by creating that 20-foot wide breach to an elevation of 1843. And that's in accordance with the DWR decision from May of 2022 and the recommendation for that breach received from Apex Engineering. In the proposed order, I put a deadline of July 1st, 2026. I arbitrarily picked that just knowing that have a short construction window here, but the board can debate that deadline and set that deadline before adopting the order. That's adjustable and can be picked totally by the board in its discretion. I noted that if any portion of the dam structure ordered for removal is to remain, that the owner of the property must apply for that permit prior to the deadline for removal, so that we know an attempt has been made, and that permit must be obtained before there's any further reconstruction or modification to the dam. I don't anticipate rollers utilizing that, but the law allows them to do that, so it's in there in case they do change their mind. Then I note, which in paragraph 4, this part, which is required by statute, just noting that if the removal is not completed by the deadline set by the board, that the board will procure a contractor to breach the dam and then will assess the cost of that contractor, plus any related expenses allowed by law, including engineering, legal, and administrative expenses against the landowner pursuant to Century Code Chapter 61-16.1. Then 2 final legal notices in paragraph 5, and just note that the board is directing my firm to notify the owners of the roller property. So that would be Linda, and we're proposing to send to the trustees of the trust, which have the remainder interest in that property, by certified mail notice of this order, and then also to Mick Thompson's attorney, which is Lucas Croker at Onstead Twitchell, notice of this order as well by certified mail. And then in the final paragraph, I just note that there's a general appeal statute that says any aggrieved person can appeal any order or decision by the water board within 30 days to Wells County District Court. So I think before acting, the board should have some discussion on that proposed deadline of July 1st. And of course, if the board has any questions for Thomas about the recommended construction for the breach or me on the proposed order or draft findings. We should discuss all those things before